True peace, Kens. It is December the 13th, 2020, and I am back at y'all with another article. This is some good information. Peep the slang. What did you expect the Supreme Court to do? Say, man, that's the headline. Share this shit. I awoke today to cries of anguish and shouts of joy as the two misbegotten sides of the political spectrum erupted in response to the news that the United States Supreme Court declined to hear arguments from the state of Texas, et alia. As I pointed out yesterday, there is a dangerous confusion caused by using the word state to describe confederate states that are actually state-of-state business organizations and not actual states at all. This exact confusion is what's happening here. The case in question was being raised by the state of Texas, not Texas. As I also pointed out, such a suit will have to be entertained in original jurisdiction, which is only accessible when one state attacks another state in international jurisdiction. So original jurisdiction can't be accessed by the state of Texas for the same reason that the state of Texas, as an incorporated entity, can't legitimately invoke sovereign immunity. A state, as I keep preaching, is not the same as a state of state. The United States Supreme Court knows this as well as I do, and knows that a state of state that functions under corporate private law in international jurisdiction doesn't have the standing to enter original jurisdiction. Texas, not the state of Texas, would have to bring the suit for it to be in original jurisdiction, and that is not even possible. Why? Because the cause, election tampering, involve a foreign-owned corporation's private elections, is my outside of Texas interest and jurisdiction. That would be like me bringing suit because the corporate providing my lawn care service held new corporate elections and cheated, leaving me to work with Joey Brazos instead of Leon Helmsley. As the employer, I can tell the lawn care corporate that I won't work with Joey Brazos because he is a known crook. And as a result, he doesn't have permission to come onto my property to provide any services. But that is not a matter for the Supreme Court to decide. That's a matter for the employer and party to contract to decide. It's apparent to me, and I hope that it is now apparent to you and to the clueless state attorney generals, that the United States Supreme Court couldn't entertain the complaint brought by the state of Texas and 17 other such confederate states because none of them has standing to enter original jurisdiction. Therefore, it is absolute no surprise that despite the gravity of the situation, the Supreme Court turned them down. The Supreme Court justice literally could not hear such a case, even if they wanted to. Instead, the published statutes of the corporations in questions, common sense, and the authority of the commander-in-chief will have to prevail. And I have no doubt that it will. As for all you reading this is an excellent lesson. Your state, your actual state of the union, is calling you to get involved in self-governance, an occupation you are here to and which you have been neglecting to your own detriment. Only your state has the standing to abide in original jurisdiction, and only you have the right and responsibility to direct its affairs.